Dear colleagues, I'm very glad that so many of us survived first day, and we are now here on the opening of the second day, on the opening of the third panel of our conference. For the technical reasons, we had to move to this so-called red conference hall. I hope that this color will encourage us to have a fruitful and active bilateral discussion today. The other advantage of this hall is that it's much closer to our coffee break point, so the transition from the active discussion during the panel to the refreshing coffee break will be much quicker, and that is another advantage of our reallocation. Today we will have a discussion with Mrs. Lilia Belfer, also with Mrs. Ani Hartunen. She will join us via Skype, and actually with me. Unfortunately, Dr. Vitaly Gutnik was not able to come to Odessa, so it will be only 3 presentations. That is why we have plenty of time for the discussion, for your questions, for your comments, for your interactions, and I hope that there will be plenty of questions from your side. Today we will have a discussion with one technical thing that you should know also. We have 2 mics. In case you want to ask some question, please ask for a mic, and you will be brought the mic. This is for recording of the purposes of recording of our conferences, since we are broadcasting, we are streaming in the internet, and to record your questions, it's necessary to speak to the mic. Okay, so now I would like to welcome Mrs. Ani Hartunen, who is who works now in the National Assembly of Armenia, that is to say, Parliament of Armenia. She works in the Standing Committee on Defense and Security. She is also a creator of the international law blog Beyond Flatland. The topic of her report is the space for gravity selection or selectiveness of cases and crimes in the International Criminal Court. Mrs. Ani. Ani, hello. Can you hear me? Nice to welcome you.
Yes, Mitra, I can hear you. Hello.
Nice to welcome you on the conference. Thanks for joining us. It's a pity that you were not able to come to Odessa, but we hope to see you on our next editions of the conference.
Thank you very much. I'm very happy for this opportunity. And yes, it's a pity I couldn't come, but I'm happy that you gave me this opportunity to do the presentation via Skype.
Thank you. So now the floor is yours. Please, you have up to 15 minutes for the presentation, and then I hope we will have some discussion with you concerning on the topic that you will present. So the floor is yours.
Thank you very much. Good morning, everybody, dear participants, dear organizers. Hello from Armenia. I'm very happy to be part of this community and part of the conference. The topic of my presentation is the space for gravity, selection or selectiveness of cases and crimes at the ICC. The title of my presentation includes a question, and my presentation will also be divided into several questions that I will try to elaborate and answer. I would like to start my presentation with my conclusion. The answer of my question in the title, the selection or selectiveness of cases and crimes at the ICC, and whether there is a space for gravity, is generally the following. I would recommend to exclude the gravity from the Rome Statute of the International Criminal Court, because, in my opinion, this concept is in the contradiction with the subject matter jurisdiction of the court. Now I would go to the several other questions, and I would like to divide my presentation into 3 main questions. The first is I will explain what is the gravity and how is it demonstrated in the documents of the Rome Statute and other documents. The second question would be, why is gravity problematic? And the final question would be, why should the gravity be excluded from the Rome Statute of the ICC? So now we go to the first question. What is the gravity, and where can we read the gravity in the documents? The gravity is included in the Rome Statute in several articles. The Rome Statute refers to the gravity in the Article 17, Article 53, and Article 54, and the gravity is referred as an admissibility threshold, as one of the two limbs of the admissibility assessment in the selection of cases. So the admissibility of the ICC consists of two parts, complementarity and the gravity of the cases. Besides the Rome Statute, the gravity is also included in the regulations of the court. In particular, for the stage of the preliminary examination, the gravity is included as an assessment criteria for the prosecutor in order to proceed further. And the gravity refers here to the crimes. At the investigation and the case selection stage, it is also included in the regulations, and it refers again to the crimes, but this time it refers to the most serious crimes to be investigated and the cases that should be selected for the further prosecutions and investigations. And finally, the gravity concept is included in the preamble of the Rome Statute as well as in Article 5, which means that the ICC has jurisdiction only over the most serious crime of concern to international community. And those crimes are reflected in Article 5. Those crimes are genocide, crimes against humanity, war crimes, and aggression for the moment, not yet. So now the second question, which is a longer one. Why is the gravity problematic? First of all, the Rome Statute, even though it uses the concept of gravity, and it refers to cases, the Rome Statute doesn't explain the meaning of the gravity, and it doesn't give any criteria how to assess the gravity. The only thing that is more or less clear is that the gravity is an admissibility threshold, and it should be assessed together with complementarity. When we look at the drafting history of the Rome Statute, it doesn't make things clear either. And what was discussed during the drafting history was mainly connected to the applicable law and the relation to the gravity. The problem was that the drafters were very much concerned about the legality principles, and they decided to take lessons from the previous ad hoc tribunals and to constrain the judges in the ICC with a gravity assessment so that new crimes are not invented. So as we can see, it was included mostly in the applicable law context and in the jurisdictional context rather than in the admissibility context. At the same time, taking into consideration the very special status and the powers of the International Criminal Court's prosecutor, the gravity of the case should be assessed not only by the judges, the judiciary of the court, but also by the prosecutor. And in fact, the prosecutor himself or herself is not given any criteria how to assess the gravity. As a result, throughout the time, the chambers and the office of the prosecutor, they developed criteria and they decided to apply it on the cases and situations. when we look at the criteria developed by the judiciary of the chambers of the ICC, the criteria are the following. The gravity is assessed based on the scale, the nature, the manner of commission, as well as the impact of the crimes. But the problem is that the case law is not coherent, and even the different chambers did not agree with each other, and in addition, they did not agree with the prosecutor and the way of the employment of the gravity. But when we look at the most recent policy paper on case selection and prioritization, the Office of the Prosecutor developed additional criteria for determining, for example, the scale of crimes, which may be assessed in light of the number of direct and indirect victims, the intensity, or bodily and psychological harm caused to the victims and their families, etc. As for the nature of the crimes, this may be assessed based on the each offense, such as killing, rapes, other sexual or gender-based crimes, etc., or whether the conduct had an impact on the cultural property destruction or the environment. As for the manner of the commission of the crimes, the criteria could be the systematic manner of them, or the intent of the perpetrators, or the organization or plan. And finally, while assessing the impact of the crimes, the Office of the Prosecutor assesses the suffering of the victims, or their vulnerability, or the terror, or economic damage. As I said, during the practice, all those criteria, they were employed not coherently. And I think the reason is that these criteria are very subjective, and it is not even, it is possible to interpret them in any ways. Also, the impact on victims is anyways grave for the victim. But how to exactly assess all those criteria as a legal category is very problematic. Now I will try to explain and analyze why the employment of the gravity criteria was so non-coherent. And I think the reason is that the very methodology of the application and the analysis of the situations or cases. First of all, the very object of the gravity was not employed coherently. The gravity of cases, the gravity of crimes, the gravity of situations, and even events were analyzed throughout the practice. And by saying the gravity of crimes, both the chambers and the prosecutor, they referred it to the underlying acts of the international crimes. What I mean by this is that, for example, when they analyze the gravity of the crime of war crimes, they analyze the gravity of the underlying acts of the crimes. That is, for example, rape, killings, conscription of child soldiers, or destruction of cultural property, etc. And as a result of this methodology, the chambers and the prosecutor, they had to analyze the gravity of these acts. For example, whether the rape committed in one way was graver than the other underlying acts. But the problem is that international crimes are not the ones that are the underlying acts of the international crimes. International crimes are only the ones that, in the context of Rome Statute, are the ones that are included in the Article 5, that are like genocide, crimes against humanity, and war crimes. And in this regard, I would like to bring to your attention the dissenting opinion of Judge Cowell in the Kenya authorization decision, where the
will try to reconnect now. I think that there are some technical problems on the Mrs. Hartunian side. In case she will be online again, we will reconnect and then proceed with her presentation. I think that the topic she tried to elaborate during her presentation is very important, and in fact, this gravity criteria is not a settled concept in the Rome Statute and not a settled concept in the practice of the International Criminal Court. I hope that we will have an opportunity to discuss this issue a bit later. Maybe our distinguished guest will comment somehow on this theme. And now I would like to proceed with the second presentation, and I would like to introduce Mrs. Lilia Belfer, who is a student of National Research University High School of Economics from Moscow. Lilia is a brilliant student whom I know from the International Law Camp in Minsk from last year, and moreover, she participated this year in the Moot Court on International Criminal Law in Moscow, where she got highest individual prize for the presentation. So I hope that you will enjoy Lilia's presentation. Lilia, the floor is yours.
Thank you. Okay, thank you. My today's topic would be the burden of proof for defenses before the International Criminal Court. The topic is quite narrow, so I suppose I wouldn't repeat the previous orators, and it wouldn't take a lot of time. So, international criminal justice, as well as national criminal justice, has to balance between the rights of a defendant and the effectiveness of the proceeding. And presumption of innocence is a cornerstone of a right to a fair trial, which is the main human right of a defendant. And so that's why providing presumption of innocence to a proper extent seems so important. International Criminal Court is the first and the only permanent criminal international judicial body which absorbs legal norms from all over the world and from different legal traditions. That's why it should be really careful in establishing its procedures. Article 66 of the Rome Statute provides presumption of innocence, according to which the burden of proof is on the prosecutor. But neither the practice of the court nor the Rome Statute provides an answer if there is any exceptions to the rule. Hence, there is an open question whether the prosecutor has the burden of disproving these offenses provided by Articles 31, 32, 33 of the Rome Statute. For instance, mental disease, self-defense, duress, intoxication, and so on and so forth. In this report, to find an answer to the question, I would address firstly to the practice and the law of ICC itself, then to the practice of the International Criminal Tribunal for the former Yugoslavia, and then briefly also to the human rights law. So firstly, Rome Statute explains further the burden of proof in Article 67(1)(i), which provides the right of the accused not to have imposed on him or her any reversal of the burden of proof or any onus of rebuttal. We should mention also that neither ICTY nor NCTR statutes has the same strict legal norm. And however, in Calixto Mbarushimana case from 26 October of 2011, the court stated that it is the responsibility of the defense to set out the basis for its jurisdictional challenge. So even if it is not a defense example, it still shows us that there could be breaches of this legal norm, some derogations, and also there could be a technical argument concerning this position of the court that this right, which is established in 67 article, it is in the part 6 of the Rome Statute, so called the trial. So perhaps it couldn't be applicable to pre-trial proceedings, and that's why we could say that there is no breach and no any connection to this article. But however, if we omit this technical explanation, we would see that it's a clear deviation from the burden of proof rule provided by Article 67 of the Rome Statute. So there could be some deviations, then maybe there could be also deviations in our defense issue. ICTY in Delilich case stated that, I quote, there are situations in a case where the accused himself makes allegations or denies the accepted situation. For example, that he is a person of sound mind. The tribunal referred to the fact that none of sources expressly prescribe the burden of proof on any party in the proceedings, and that it's a fundamental requirement of any legal judicial system that the person who desires the tribunal or court to take action on his behalf must prove his case to its satisfaction. Though the position on this issue of ICTY is well-reasoned and established, International Criminal Court should be very careful while applying it, because as ICC stated in the Lubanga case, the International Criminal Court statute has, through important advances, created a procedural framework which differs markedly from the ad hoc tribunals. So, and we should also remember that in ICTY statute there is no such article similar to the mentioned 67 article, so there is only a presumption of proof of innocence. Excuse me. So we looked into practice, main practice concerning the issue of this issue in ICC and ICTY. So let's try also to look a little bit in human rights law. So European Court on Human Rights also addresses the issue in connection with Article 6, Paragraph 2 of the European Convention, which establishes the presumption of innocence. And the court's position is that presumption of innocence is not absolute and it could be reasonably limited. Thus, in Selebyaku versus France case, the court stated that this article requires states to confine the presumption of innocence, presumption of fact or of law within reasonable limits, which take into account the importance of what is at stake and maintain the rights of the defense. That means that European Court of Human Rights has the lower standard than those which could be derived from the strict interpretation of the Article 67(1)(i) of the Rome Statute. So it's another argument in support of the tribunal's decision. I would also like to add that although this question is highly controversial, we can't foresee when it would arise before International Criminal Court. Because in such high institution with high qualified lawyers, defendants usually provide the court with arguments and evidence which raise at least reasonable doubt in the judge's mind, because it's more correct tactics than just say that we don't oblige to do it. So therefore, even if the defense legally really isn't obliged to do it, it could do it, and because of mentioned tactics, the court perhaps would be able to avoid this controversial question for some period of time. To conclude, as argued in doctrine, what this right established in Article 67(1) I of the Rome Statute will mean in practice is not entirely clear. So the further guidance from the International Criminal Court is awaited. For now, it seems that it would be still difficult to interpret this article in a way that would allow us to have any exception. But however, the CTY's position and human rights position seems more rational, so International Criminal Court could try to avoid this article in a technical way, as it did, for instance, in jurisdictional example of Callisto Mbarshimana. Thank you.
Thank you, Lilia, for very topical, raising very topical issue. It's really in the very core of contemporary international criminal law discourse. And now we have Annie back on Skype, so we'll try to reconnect with her and to end her presentation.
Hello.
Hello, Annie. Sorry for these technical problems. Now we are here. We are seeing you, and yeah. You can proceed with the presentation, please.
Thank you very much. I will proceed to the last part of my presentation on the question of why should the gravity be excluded from the Rome Statute. And the answer is because it interferes with the jurisdiction of the court. And the very idea, principle of the admissibility and jurisdiction is that those two concepts are separate. And to explain why it interferes with the jurisdiction of the court, I would like to bring the dissenting opinion of Judge Cowell in the Kenya authorization decision of the pre-trial chamber. In this decision, the majority came to the completely different conclusion than Judge Cowell because they employed different methodologies. And the main argument of the Judge Cowell was that he couldn't find enough evidence to conclude that the contextual elements were satisfied. And concerning the gravity issue, he emphasized that it is not the cruelty or mass victimization that turns a crime into a crime under international law, but the constitutive contextual elements in which the act is committed. So he put a demarcation line between the national law and the international law, and the crimes under national law and under international law. So for example, if we take the crime of rape, it is a crime under national law, but under international law, the rape itself is not a crime. It is a crime only if it is a war crime or part of a crime against humanity or an act in the context of genocide. So when we go back to the criteria of defining the gravity, for example, the scale of the crimes, it includes, for example, high-intensity crimes. And intensity is also used to come to a conclusion about the contextual elements of the international crimes, like to, for example, to define whether a non-international armed conflict existed or not. As to the nature of the crimes, the criteria put by the prosecutor include, for example, whether the crimes resulted in the destruction of cultural property or whether they included killings or rapes. This is problematic because if we employ these criteria, then it brings a lot of subjectivity, and the prosecutor decides which crimes are graver based on subjectivity. The manner of the commission of the crime, it includes systematic nature of the crime or the plan of the commission of the crime. And in the jurisdictional part of the International Criminal Court, the crimes against humanity themselves, the contextual elements of crimes against humanity, they include the systematic or widespread nature or the plan. Also, in the manner of the commission of the crime, the intent is included. And the intent, it is included also in the crime of genocide. So as we can see, the criteria for gravity to assess the gravity of cases in the admissibility as an admissibility threshold, it equals the context and the content of the crimes themselves. So there is an interference and collision between the jurisdiction and the admissibility under the International Criminal Court. That's why that was my conclusion. So that it would be more predictable and it would contribute to the legitimacy of the ICC better if the gravity as an admissibility threshold would be excluded from the Rome Statute. Thank you very much. I would be happy to answer your questions concerning this issue.
Thank you, Ani, very much. And now I think that it will be wise to collect some questions to Ani and then proceed with the third presentation of our panel. So please, are there any questions to Ani concerning this gravity criteria? Please ask for a mic to ask the question. I see you there. Do you want to ask? Yeah. Maybe.
Thank you. So I have a question. First of all, of course, thank you for your presentation. But I have a question. You said that the gravity should be excluded from the Rome Statute. And I think that, but why we can't just establish some certain criteria which could not be, they would not be subjective. So, for example, based on the principle of, for example, proportionality of victims or so, could it be really effective?
Mm-hmm. Thank you. Should I answer the question now or after all of the questions?
I think you can answer now and then we will collect other questions.
Thank you very much for your questions. It's a great question. Why is it not possible to establish a criteria? There have been many steps to establish the criteria, both by the court, the chambers themselves, and the prosecutor. But the problem was that it was not successful, and there are many questions. How should you establish the criteria? First of all, you have to answer the question, the gravity of what? According to the Rome Statute, it is the gravity of the case. But in practice, it was also referred to the situations, the events, the crimes. And while saying the crimes, in practice, it was referred to the, as I said, underlying acts without considering the contextual elements first. And it is very difficult to compare what is graver, rape or killing. And in reality, if you really want to establish a relative gravity to compare crimes, you have to compare the crimes under international law. Those are the crimes of genocide, crimes against humanity, and war crimes. And this is debatable, which international crimes are graver. In case of the war crimes, even in the Rome Statute, we have the Article 8, which gives for example, the Article 8.1, it says, the court shall have jurisdiction in respect of war crimes in particular, when committed as part of a plan or policy, or as part of a large-scale commission of such crimes. So this provision is included in the jurisdictional part of the Rome Statute. But if we employ this in addition to the admissibility gravity, which would probably include the same criteria, then there is a collision. So many commentators, they try to develop some criteria for gravity, but since the last decision on the matter was published, there were no criteria that were clear, that were legally predictable, and that would be a guide for both the prosecutor and the chambers. And this is the reason that, for example, in one of the recent situations in the Gaza flotilla, the chamber came to the completely different conclusion than the prosecutor, and then they both employed the same criteria, actually. So this is very subjective. That's why my argument is that and this is a legal criteria, this has to be clear and predictable, that in practice it was not possible to develop some guidelines. That's why this collides with the jurisdiction of the court, so that would be more predictable to exclude this. But I would be happy if criteria would be developed.
Thank you, Ani. Are there other questions among the participants? Judge Ušacka, please.
Thank you very much. Hello. Thank you very much for your presentation. I'm very happy that you mentioned my colleague, Judge Kaul. Unfortunately, he passed away and left us 2 years ago. And of course, his dissenting opinion on Kenya and something similar in the Côte d'Ivoire case. It's a very interesting question, which is still in the air of definition of crimes, because actually his approach is not totally new. It's coming from Tokyo Tribunal, where in one of the cases, Dutch judge also expressed the same opinion, that it is not international crime, that it's national crime. And actually, unfortunately, this issue did not come to appeal chamber. It was in the air. Of course, if it come to appeal chamber would be forced to say on this issue. But it's clear that from this time of Tokyo Tribunal and now, it's a lot of changes, conflict changed, nature of conflicts changed. And it's very important, of course, especially about crimes against humanity, to show these elements. What is important? Is it really state should be always part of this, or it's not necessary in some conflict? But in future, I hope it will come, and of course, we need to be patient, we need time. And the second is a question which not relate to your presentation, but about ratification of Rome Statute by Armenia. Because 2 years ago, I was in Yerevan, invited by Red Cross. It was conference about position of Armenia, but time is passing and we don't have any results. Would you elaborate a little bit about this? Thank you.
Annie, the floor is yours now.
Can you hear me? Can you hear me, Dmitry?
Yes, now we hear you.
Yeah, thank you very much for your question. It's a great question. Armenia has signed the Rome Statute, but it has not ratified the Rome Statute for the reasons that it was against our constitution. And on this issue, there was a decision, an opinion of Constitutional Court of Armenia, and the court conclusion was that the Rome Statute is against the Constitution.
It's a pity that we are experiencing these technical problems again.
Whether the government would like to proceed to the ratification, we will see. I mean, we have conflicts apparently, and I think it's in our interest to be part of the international criminal justice, but I think maybe there would be another decision if the question arises. But whether the question arises in the future, I don't know. Right now, I don't know. There are no concrete discussion, open discussion. So we will see. The time will show.
Thank you, Annie. I have also one question to you. You say that this gravity criteria is in contradiction with the contextual elements of crimes, actually with jurisdiction or materia. And from what you said, it seems to me that it's not a contradiction, but rather repetitiveness of the same criteria for contextual elements, for establishment of contextual elements existing, and for establishment of gravity existence. Can you clarify on this point, please?
Yes, Dmitry, it's actually, yes, it's rather an interference. The gravity criteria, they are interference with the jurisdiction of the court. And the collision was between the two concepts, jurisdiction and admissibility. In international courts, those two concepts are separate ones. And when you assess the issues of jurisdiction and the issues of admissibility, you assess them separately. But in case of the gravity criteria that are employed currently, those two issues, they interfere with each other, so the collision, the conceptual collision occurs.
Thank you. Are there any other questions? Lilia, please.
Thank you, Annie, for your presentation. My question is concerning war crimes. So I understand that crimes against humanity and genocide, they are really brave by its nature because of contextual elements. But what about war crimes? It seems to me that just having international or even non-international armed conflicts is not a gravity situation. So if we would exclude now gravity from the Rome Statute, don't you think that ICC would need to investigate such crimes as, for instance, killing of one person in international armed conflict? And it would be really a lot of cases. Thank you.
Thank you very much. What I meant was that even if we exclude the gravity from the admissibility, and while usually war crimes, they are committed even, war crimes are more in quantity. Even in this case, there is no danger that there will be overload of cases because of the Article 8.1. And the Article 8.1, it gives the opportunity to select cases by the wording. In particular, because it says the court shall have jurisdiction in respect of war crimes, in particular, when committed as part of a plan or policy or large-scale commission. So it gives an opportunity to not proceed with very peripheral cases. And it gives the opportunity to concentrate on the war crimes that are large-scale or part of a plan or policy. So it's not a requirement, but in particular, you can proceed with investigating such crimes, such war crimes. Is it clear? Was it the answer of your question?
Yes, thank you.
Thank you, Ani, very much for joining us. It was really very interesting, a very fruitful discussion, I think. I hope that next time you'll be able to come to Odessa and to speak before the audience in person. Thank you once more.
Thank you very much. Once again, it was a pleasure to participate in this conference. Good luck.
Thank you. Now it's time for my intervention. I would like to share my mind with you concerning the contextual elements of international crimes. They were for several times mentioned already during our first day and today even. So I would like to a bit clarify what are these contextual elements about and where have they come from. It's actually the topic of my presentation. When I started to think about contextual element, it was unclear for me where this concept, from what national legal system this concept derived. It was clear, however, that it was not an invention of the creators of the elements of crime, because literally the wording contextual elements appeared only in elements of crime, not even in Rome Statute. So when we take as granted that contextual elements appeared earlier, we have to find the origins where these elements were firstly appeared. I think that that contextual elements actually were embodied in the corpus delicti of national crimes. I would like to make only two examples to prove or to prove my position or my perception of these theories of this of the idea that contextual elements derive from the national legal systems. The first one is the wording, the quotation from Judge Jenkins from the 17th century. He defined the piracy as the robbery that occurs on the sea. In the sea. In this sense, piracy is a robbery with a special contextual element occurrence in the sea. If we approach contextual element in such a way, we can say that contextual elements actually transform so-called mala in se crimes or natural crimes into mala prohibita crimes or crimes that are defined as crimes by the laws. Another example of this kind is the USSR law of Spiegels, also called 7/8 law from the USSR, adopted in 1932. And this law, you can see, I hope, can we proceed with the slide a bit? And one small. Yeah. So here you can see the quotation from that law. It reads as follows: the communal property, state, kolkhoz, or cooperative property is fundamental for the Soviet social order. Therefore, people who try to appropriate it must be treated as enemies of the people. According to this law, if the crime is committed and it harms the Soviet social order, the punishment may be a death penalty, even if only 5 spiegels are stolen. So this danger for Soviet social order is also a kind of contextual element for the very simple crime, very malignant crime of robbery, for instance. If we approach contextual elements in this way, we can say that in national system many crimes have these contextual elements embedded in the corpus delicti. Contextual elements were not actually the invention of, they do not come from international law itself, but rather from national law. But in national law, they were never named as contextual elements. They were named as circumstances, as some special occasions when crime can be committed, but not as contextual elements. Can we proceed to the next slide, please? In international law, contextual elements also appeared first appeared also not in Rome Statute, not in the practice of International Criminal Court, but rather in the previous statutes. In criminal law theory, it's called contextual embedding of international crimes. For instance, in the statute in the London Charter of International Military Tribunal, there was so-called war nexus. The crime should be committed in connection with war to be the court, the tribunal, to have jurisdiction over it. For instance, crimes against humanity should be connected somehow to the war that Nazi Germany started against other states, the International Military Tribunal to have the jurisdiction. So the war nexus is indeed a contextual element of crime against humanity, for instance. In ICTR and ICTY practice, there were also several contextual elements. Several elements were used to contextually embed crimes, let's say. For instance, widespread and systematic character of crimes. This contextual element was used to research the crimes against humanity, to state that crimes against humanity occurred on the territory of either Yugoslavia or Rwanda. Then the tribunals studied the issue of existence of international or non-international armed conflict. Also, with regard to Rwanda tribunal, they studied the existence of discriminative nature of the crimes when it comes to crimes against humanity again, because in Rwanda tribunal statute, the definition of crime against humanity was a bit different from that we have in the Rome Statute. And finally, the contextual circumstances were included into the elements of crimes, the document that is called Elements of Crimes, after the adoption of the Rome Statute. In the Rome Statute, there are several, we can proceed further with the slide. In the Rome Statute, there are several contextual elements that included to the 3 categories of crimes. First, genocide. It's a most contradictional, I would say, crime in terms of identifying what are contextual elements of this crime. The only expressly or literally mentioned contextual element in the elements of crime is a context of a manifest pattern of similar conduct. Of course, we know that there are some doubts concerning the fact that whether we can consider this element as obligatory for the court, but the majority in Al-Bashir case stated that this element should be considered as the part of the corpus delicti of the genocide crime. In the literature, genocidal intent, special intent of the attack against national, ethical, racial, or religious groups is considered also as a part or as a kind of contextual element, or the so-called contextual element on the mens rea side. When it comes to crimes against humanity, the widespread or systematic character of the attack against civilians and the knowledge that the conduct was a part of the attack are considered as a contextual elements of of crimes, and also in the preamble to the crimes against humanity and the elements of crime, the other contextual element is mentioned. It's existence of states or organizations' policy to commit such an attack. As for war crimes, there are two contextual elements directly mentioned in the elements of crimes. It's the existence of the international or non-international armed conflict and the awareness of factual circumstances that establish the existence of an armed conflict. This is about a few words about the origins of contextual elements, and now I would like to go further and open the second part of my address. That is about the purposes or the goals that contextual elements fulfill, being included into the corpus delicti of international crime. And I would like to introduce this man. His name is Wilhelm Wundt. He is a German philosopher and psychologist. He is relevant in our discussion since he introduced a very interesting concept, the concept of heterogeneity of ends. This means, according to Wundt, that the ends or the goals of some action or some legal provision, let's say, not always appears not only, sometimes it appears during the course of activities. So not all the goals of contextual elements were foreseen by the creators of the Rome Statute and by the creators of the elements of crime. Some of them appeared later, or maybe we can see that contextual elements have some were included into the elements of crimes for some special purposes only in the course of jurisprudence of the application of the Rome Statute and elements of crimes. So the first goal, the first function, let's say, of contextual elements is the legalization of intervention. It is well exemplified by Luhmann, who wrote about 4 stages development of crimes against humanity. According to Luhmann, the first stage, or the stage of so-called unprotected tyrants in the ancient times. In that times, tyrants and dictators were able to do whatever they want, but in case if their crimes, their conduct was too severe, there were when severe violations of the law of God happened, the nations were able to overthrow such a tyrant or dictator, and in some sense, this severity of violations was a contextual element of the pre-modern, of the ancient crimes against humanity. On the second stage, the concept of sovereignty appeared. It was 17th century when this concept crystallized in the international law, and as some kind of balance or counterweight to this concept, the concept of humanitarian intervention appeared. The first humanitarian intervention occurred in the 19th century when the United States intervened into Cuba, when Russian Empire intervened into Bulgaria, British Empire intervened into Lebanon, some other countries of the region. So this balance, it was possible to activate this counterbalance of humanitarian intervention only in case if a large-scale violations of human rights occurred. So the large scale is was kind of contextual elements for the crime against humanity in that period. Then Nuremberg and Tokyo tribunals became established, and in that tribunals, as we discussed earlier, the war nexus was a contextual element of crimes against humanity. In ICTR, ICTY, and ICC, war nexus again discriminative character of the attacks, widespread and systematic attacks were the contextual elements. All these contextual elements, according to Luhmann, helped the international community or the national communities to decide on the intervention into the tyrants, into the rulers' policy of severe violations of human rights. So in some sense, contextual elements legalize the intervention against the state or against the ruler, the tyrant of particular actor of the international relations. The second function of the contextual elements is a delimitation of jurisdiction. It's a bit similar to the previous one, but the accents are reallocated here. The president of the first president of the International Criminal Court, Kirsch, mentioned this function of contextual element. According to him, the contextual elements play a very important role in realization of principle of non-intervention into the internal affairs and in manifestation of legitimacy of international jurisdiction. And in this way, contextual elements delimit national and international jurisdictions. Also, and we go now to the next slide, contextual elements orient the international criminal courts on the acts of others. All the international crimes may be committed only, not committed, of course, but the court can state that some international crime occurred only if the court studied the behavior or the conduct of others. And the link between the conduct of actus reus of particular offender and the conduct of others is made by the contextual elements. The absence of a connection between actus reus of particular offender and the conduct of others means that the particular action may not be interpreted or as an international crime. This is not in contradiction with Article 25 of the Rome Statute that prescribes the modes of participation. Since modes of participation is a bit different concept. In case of orientation on the acts of the conduct of others, we do not need, court do not need to establish the involvement of others into the crime, but simply to stress or to make a conclusion that such conduct is kind of similar to the conduct of a particular offender, and that the actus reus of the particular offender occurred in the context of the conduct of others. The next function of the contextual elements was mentioned by Kevin Heller in his blog post, and it's kind of sociological function of contextual elements. According to Heller, contextual elements help the court to distinguish the producers of social political context and the consumers of social political context. For instance, the president of state that create the policy of widespread attacks against civilians create the context of international crimes. But the middle rank official of that state is not a creator of the context. It's he or she is a consumer of the context. And for the court, this has a very concrete consequences for the court and for the prosecutor. Prosecutor, in case of the producers of social political context, has to establish, has to find or to elaborate on the whether the particular person really produced, created the context, really made some statements that helped to establish the policy, or create maybe issued maybe some document that helped to establish this context. And in case of the middle rank officials, middle rank military commanders, the court have only to get to know whether this middle rank commander knew about the context, whether this military commander or official understood what this context was about. Then the other function of contextual elements is a definition of serious crimes. Contextual elements identify the proper audience interested in punishment of the offenders. According to Duff, crimes with contextual elements, it's a concern of international community, and crimes without contextual element is a concern of local communities. It's not an uncontroversial statement, but still it has some logic. In fact, when the crime consists, when the contact is accompanied by the contextual elements, we can say that international community is concerned about this crime. But when the contextual element is absent, it's usually the concern of local communities. It's the local communities who should react on the crimes through some legal mechanisms. Also, this next slide, the contextual elements helps to fulfill the Article 30 provision. Article 30 reads as follows: unless otherwise provided, a person shall be criminally responsible and liable for punishment for a crime within the jurisdiction of the court only if the material elements are committed with intent and knowledge. In fact, when contextual elements are in the material side, for instance, when it comes to widespread or systematic character of the attack, we cannot establish the mental element of the other side of. We cannot say that this material element is accompanied by the proper mental element, respective mental element. So contextual element helps to fulfill Article 30 by creating a third additional element to the corpus delicti of every crime, contextual element, not a material, distinguished from the material and from the mental one. Last but not least, contextual elements help to minimize the state's concern concerning the with regard to the proceedings in the international criminal court. When the crime consists of when the corpus delicti of the crime have this contextual element, the states are not that concerned about the proceeding in the international criminal court. Since the contextual element help to limit the scope of international jurisdiction, and this is of course very good for the states, since they usually want to live in their sovereignty, usually perceive the criminal investigations and criminal prosecution as their sovereign issue. Since contextual elements limit this international jurisdiction, it also limits the concerns about the interference into the internal affairs. Thus, as we can see, contextual elements play a quite important role in the in the corpus delicti of international crimes, and it's really a distinguished characteristic of the international crimes nowadays. Thank you. I'm done with my presentation, and now I think we can open the floor for the questions. I would like to remind you that you can now ask the questions concerning my presentation and also concerning the presentation of Mrs. Belfer. She spoke about the burden of proof. I see at least two hands. We can collect these two questions and then proceed with the answers. So please.
Hi. 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 My name is Vitaly Vlasyuk. I'm PhD from Kyiv. I'd like to remind that Mr. Lavrov, we know who is Mr. Lavrov. A year ago, he put an open question: what is humanitarian catastrophe? So I'd like to redirect to you this question, and how could we and how would we define it under international law in the context of ICC activity? Thank you.
Thank you for your presentation. My name is Danilo. I'm from Kyiv. So my question is, this year, as I mentioned yesterday, is the year of Kampala amendments, and my question is, how do you personally define the contextual element of the crime of aggression? Thank you.
Thank you. Ms. Biffer, do you want to start with the first question? It was about the humanitarian catastrophe and what does international criminal law say about, how does international criminal law define the humanitarian catastrophe, if it does?
Well, thank you for your question. I couldn't say that a Rome Statute says anything about humanitarian catastrophe itself, and I understand that it's also connected with humanitarian intervention and maybe now also with right to protect mostly, but I agree that it's really vague conception because we wouldn't find any criterion for this, but I think that mostly we should think not about material, maybe definition of humanitarian catastrophe, which would be really difficult to establish, but about procedural definition that we could apply to, for instance, United Nations organs, which could, for instance, General Assembly could make resolutions, and if some UN organs would define the situation in a certain region as humanitarian catastrophe, then maybe it would be in a better way ready to define and to intervene. Because without procedure, I think we couldn't apply definitely to this question.
Maybe I can add something, some few points about on this question. I think the humanitarian catastrophe, the concept of humanitarian catastrophe is really vague, and it relates a bit to the concept of mass atrocity crimes. When mass atrocity crimes occurs, there is a humanitarian catastrophe. And mass atrocity crimes, according to the United Nations General Assembly, they're actually international crimes. So it's war crimes, crimes against humanity, and genocide. Thus, we have a humanitarian catastrophe if in some region international crimes are occurring. What international criminal law can do to stop the humanitarian catastrophe is to bring justice to the region. When international crimes are committed, International Criminal Court may intervene if national organs, national courts are unable or do not want to be involved in the situation, and then International Criminal Court may help to bring justice to the region. So it's how international criminal law can react on the humanitarian catastrophes. As for the contextual elements of the crime of aggression, in fact, if we read the Kampala Amendment, we cannot say whether contextual elements are included into the definition of the crime. It seems to me that for now there are no neither in the Rome Statute, neither in the Kampala Amendment, nor in amended elements of crimes, clear contextual elements of the crime of aggression. There are only material and mental elements. However, for instance, the high position of the offender may be in some circumstances seen as contextual elements of this crime. If we perceive the high position of the offender as a contextual element, then we can say that crime of aggression includes some contextual elements at least. But for now, it's not clear. It's not clear, and mainly all commentators does not speak about some contextual elements included into the corpus delicti of crime of aggression. Some other questions, comments? Yeah, Dr. Wilkitsky, please.
Thank you. Not really a question, but a short comment. If you allow me to come back for 2 minutes to our yesterday's discussion, you may remember that after my presentation I was asked what I personally think about the contextual elements in connection with the complementarity. And I had said that I personally thought it was not absolutely necessary to have the same contextual elements in both the international, the ICC statute and the domestic law. I just want to avoid that I'm being misunderstood. I don't doubt at all the necessity of contextual elements in both international and national laws, and I subscribe to everything what you have said. But what I was commenting about was just the notion of contextual elements in the assessment of complementarity. And there I still think that it's not absolutely necessary that the law of the state which has to be assessed whether it's sufficient or not for coming to the result there is complementarity or there's not, that this should not be absolutely necessarily the same notion. And but I would stick to the opinion that that the main element of complementarity is the avoidance of impunity. And if a state, say Kenya in this example, is able and willing to judge this offender and gives him maybe for murder, for normal murder, a life sentence, then for me it doesn't matter whether they have the same contextual elements. Only this I wanted to say. Maybe this is also, my opinion is also due to the German speciality that we are worldwide the state with the broadest notion of the set of facts of the offense. For us, we have the same problem in extradition for double criminality. We have the same in nebis in idem for same offense. And we always say if it is only, we come to the same result, it doesn't matter whether it's in the one state is arson, and the other one is insurance fraud. So what? If he gets his 10 years, fine. Only that I wanted to say, and don't understand me in a sense that I wanted to doubt about the necessity of contextual elements.
Thank you, Dr. Wilkitsky. In fact, in national laws, there are really different contextual elements. I don't know national law that implement the contextual element from the elements of crimes in terms of crime of genocide. No national law had this provision of the behavior of others, of the similar line of behavior of others. And when it comes to war crimes, it's also very differently interpreted in different national laws. So, in fact, there are different contextual elements in different laws and in international level. As for the fighting impunity, in terms of fighting impunity, I think that it really does not matter whether some person charged for simply murder or for crime against humanity. But in terms of creating the collective memory, in terms of influencing the perception of the events, of the crisis, it really matters for the historians, for the writing of the history of the crisis, writing of the history of some mass atrocities. It's really important to name the offenses by their real name, either genocide or crime against humanity or war crimes. So in sociological sense, it's a bit important whether it's a regular murder or it's a murder as a crime against humanity. Thank you once more. Some other, I think, no? Don't you want to? Judge Ušacka, please.
On Lilia's presentation, which touched very interesting issue, presumption of innocence. And I would like, I remember problems we faced and still face in ICC with cases of interim relief of imprisoned persons. They have the right every 6 months to come to the court and to ask for interim release. And in all cases till now, prosecutor, of course, should prove why this person should be in prison. And usually in all cases, the facts are very, very similar, like this person can escape, this person can commit new crimes, to influence witnesses, to destroy evidence, the person have enough financial funds hidden. But actually, these are words, but there are no proof, and it's very difficult for prosecutor to get proof from Congo or from Cote d'Ivoire, for example. And so it's some kind of game every 6 months. Every 6 months, these persons are coming, their lawyers, trials chamber, for example, making decisions. These decisions are appealed, they are coming to appeal, and again, appeal sent back to the chamber asking for more evidence, and it's actually very difficult to prove this for prosecutor. Of course, there is always danger that these persons will escape, and then the question is why Rome Statute has so much legal norms, many legal norms about these issues. And this, of course, words of onus lies to prosecutor. It's in many, many cases of interim release. Then second, just very short question to Dmitro. It was very, very interesting presentation. I heard new names, yeah, but historically, yeah. But I would like to ask you, where is Grotius, Hugo Grotius, in this concept of contextual elements and humanitarian intervention? Do you just whether he fits in this? Yes. Thank you.
Yeah, I think, Lilia, do you want to comment first on what was said?
I can just quickly comment that I personally really don't know even what is better to make person waiting for years imprisoned, even and not proven to be guilty, or it's better for the court to let a person escape and catching them everywhere, and sometimes it is not really legally speaking, illegal catching, and then there could be a problem with proving if ICC has right to investigate a case and a person who is not legally carrying to the court. So I personally don't know even what is better, and I understand this issue. Yeah.
Thank you. What I did not tell, of course, every case is different. If we look to Bemba case, Bemba with his big family was living already for some time in Belgium. He had wonderful recommendations, even from members of parliament, assurances. And for example, case of Cote d'Ivoire, former president of Cote d'Ivoire, Gbagbo, he was very sick. He had very big problems, and what is now a little bit optimistic that finally trial chamber asked prosecutor to give better evidence why he needs to be kept in detention, because it's already more than 5 years, and maybe trial will go for 2-3 years or even more. So maybe we will see some development or some mechanism how to supervise these people. Thank you.
I would like also to reflect very quickly on the question concerning Hugo Grotius. Actually, I was not thinking about Hugo Grotius when I was writing this text, but in fact he fits this concept, since he's distinguished of legal and illegal wars. is a bit similar to what Luban said about the second period of development of crimes against humanity, the period that was about the sovereignty and the counterbalance as a humanitarian intervention as a counterbalance. When it comes to just war, sometimes just war may be started to stop the violations of human rights. And in this sense, in fact, to start the just war, the contextual elements of the crime should be present. It should be the large-scale violation of human rights. If I may abuse a bit my position of moderator, I would like to ask Lilia another question. One more question. You said that maybe it will be wise for the International Criminal Court to apply the limited understanding of this burden of proof. What should be the limits of this limited understanding? Or how should the court limitedly understand the burden of proof?
Well, I would say that it should take this ICT-wise approach, and perhaps the problem is also that burden of proof can be split into legal burden and evidence burden, and perhaps maybe it should leave legal burden on the prosecutor as usual and give evidential burden to the defense, of course only in cases like defenses, and also maybe it should be decided on case-by-case basis, because sometimes, of course, all cases are different, so sometimes maybe prosecutor can give better evidence, for instance, that it was self-defense than the accused herself. So I would answer briefly that it should take a ICT-wise approach, but also carefully in, well, case-by-case basis. Yes, thank you.
Thank you. Are there some other questions or comments? I see no. One also, no? Okay. So now we have time for coffee break, for small refreshment, and then we will proceed with the fourth panel, the last panel of our conference. Enjoy your coffee and tea, please.